Thank you very much, Chair. Thank you, Mr. Ricard. Thank you, Mr. Adeleke. So, ladies and gentlemen, today we have none other than Mr. Babatunde Rikera. And I don't think that he needs any introductions, but I will, for the purpose of formality, still introduce him. Mr. Babatunde Rikera is the pioneer executive vice chairman and executive officer, chief executive officer, my apologies, of the Federal Competition and Consumer Protection Commission. With over 3 decades of legal practice, he has been instrumental in building and leading Nigeria's foremost competition and consumer protection authority, where he championed landmark reforms, investigations, policies that promoted fair markets, safeguarded consumer rights, and strengthened regulatory stability. His career spans roles as in-house counsel, general counsel, managing partner, and advisor to senior government institutions, giving him broad expertise in competition law, consumer protection, civil rights, litigation, regulatory framework, and government relations. Babatunde also played a pivotal role in advancing aviation consumer protection in Nigeria, including developing the Passenger Bill of Rights and revising aviation economics regulations. He is admitted to practice law before the Supreme Court of Nigeria and the Washington State Supreme Court, and is widely recognized for his contributions to both national and international competition and consumer protection discourse. Ladies and gentlemen, I believe you would agree with me that there is no other person who is more suitable, more equipped to take us through, an introduction to competition law to help us understand the raison d'etre of competition law. Why do we need competition law? How does it apply in our market? And so please join me in welcoming Mr. Babatunde Rikera. One more housekeeping rules, please. Please let's use the Q&A box. Those questions from there. Thank you. Mr. Rikera, sir, over to you.
Good afternoon. Oh, sorry, good morning. I'm in the afternoon where I'm speaking from. And thank you very much, SBL. Thank you, dear friend, Mr. Chairman. Can you hear me?
Yes, we can hear you. Go ahead.
Yes, we can hear you.
And thank you very much, Moriah, for asking me to speak on this. And thank you for making it Competition 101. Because I suspect if it was a little more advanced, I might have had trouble being able to address gatherings such as this that has people like the chairman of the committee, who himself has a graduate degree in competition law. But I speak today and try to go through what I think might be just a basic reasoning behind competition or antitrust regulation, and speak a little about the history of it, the purpose, and the benefits, and then the practice of it. And so I'll start with the history. Competition law is not really, it might be new in our terrain, or even globally, but it's actually always been part of trade. Its fundamentals are based in the natural human nature. And there are philosophies out there that say that companies, by their very nature, are predatory. That's arguable, and depending on what side of the philosophical aisle you fall on. But because companies are basically set up to make profit, and will do anything to make profit, guardrails needed to be placed from a legal standpoint. And those guardrails were to protect everybody. And so one of the big bases for starting competition was government in the United States, starting there about the 18th century, actually, in the 1800s, sought to control monopolies and to promote fair competition, meaning that there were businesses that were big and they were allocating the markets to themselves and they were conspiring. And so, and this was happening right about the first industrial revolution. And it was in big markets like steel, banking, oil, which were the key industries at that time that were going to ultimately power what became the successive growth of global economics. And so governments were interested in making sure that economic concentrations were otherwise discouraged or promoted, and actually prohibited monopolization at the time. And the history of it from a legislative standpoint started, I think, by about 1890, and that was the Sherman Act, which was the first antitrust act in the United States. It was the first major piece of legislation, and it prohibited contracts, combinations, and conspiracies in restraint of trade, and obviously prohibited monopolization also. I'd say about 14 years later, in 1914, the Clayton Act, which was really just a revision of the Sherman Act that was really to strengthen the legislation. And it was the first piece of law that created both the public aspect and the private aspect of antitrust regulation and enforcement. In 1914, also, you had the Federal Trade Commission Act, which established the Federal Trade Commission of the United States to administer the antitrust law in consonance with the U.S. Department of Justice. However, apart from the legislative and the institutional um, development framework, there were also case law. And many of you will probably have heard of the Standard Oil. It was a premier case in competition regulation. And so Standard Oil was this massive oil company, and of course, oil was one of the big areas of concentration and monopolies at the time. And in 1911, the state of New Jersey and the US federal government sued Standard Oil. And what ultimately happened was that Standard Oil was broken into 34 companies. And so your ExxonMobil, your Phillips, your Conoco, your Texaco, and an incredible number of really large multinational oil companies that we've come to know all over the world, especially in the United States, were broken out of one single oil company. Exxon was a different one, Mobil was a different one, Conoco was a different one, Phillips was a different one. Of course, you see that some of those companies at the turn of the century, they've recombined now, but they were all broken into smaller companies at that time. And that was the first case. In the same 1911, there was also the United States against American Tobacco Company. And what that did was to dismantle what was known as the Tobacco Trust. So at the time, tobacco was really the business of a small group that formed what you call the Tobacco Trust. And so that's where you have the British American Tobacco Company, R.T. Reynolds. In fact, they broke into small companies, Altria, Philip Morris, R.T. Reynolds, and all of that. And over the years, again, at the turn of the century, you've seen some of those combinations come back. And so that's both the legislative and the potential case law history. By 1957, after the Second World War, Europe too had gotten with the program and had started competition regulation. But one thing that's marked the trajectory of competition regulation is that between the 1930s and the 1960s, you could see that, especially in the United States, the real focus of competition regulation was market structure, trying to define a market that could be efficient, that could admit everybody, and that could be fierce, and that could compete, and that could allow others to really just play fairly. Essentially, balancing the playing field or eliminating entry barriers. And that was what it was between the 1930s and the 1960s. But I would say by 1970 through the 1980s, there was a shift to what is now known as consumer welfare. So essentially, I saying that, okay, we've tried to open up the market. Businesses are finding their way. But even after opening up the market, they see that the businesses they opened the market up for, the ones who screamed, the smaller ones at the time, when they came into the market, obviously started becoming exactly what the reason why competition regulation was started in the first place. And so there had to be a shift from looking out for other companies to looking out for the consumers, since this was market regulation. And in the 1970s, consumer welfare was becoming a big thing. The social issues, capitalism had been experienced. Experienced. The experiment had worked, and they were seeing that the predatory nature of businesses and the eat what you kill approach to capitalism and the winner takes all was becoming dominant. And so it became very important for governments to find some kind of balance between, instead of balance between companies, now you wanted to find balance between companies and consumers. And so consumer welfare and consumerism and consumer protectionism became quite a dominant area of advocacy at the time. And so between the 70s and the 80s, consumer welfare became a dominant factor. And that is what really most of the newer competition regulatory authorities have uh, um, emerged to see, that what is in the best interest of consumers. And it was quite possible to see that the market structure and consumer welfare were not mutually exclusive. You could actually pursue consumer welfare, and to the extent that things were in the interest of the consumer, you could actually focus and regulate this market structure also. But what is interesting is that starting in the 90s and certainly up to date, and even more and more starting today, there's been, you can see what really is a trajectory of shift again. And that is more with big tech. The digital platforms present a brand new challenge that was not contemplated by the early evolution of competition regulation. And some of the key things which regulators are having to be creative about and having to really leapfrog and work very hard to get with and develop new theories. And I'd say that Nigeria is one of the countries that has been successful in challenging and taking a strong stand, and is actually globally respected for some of the new theories of liability and accountability that have been established for digital platforms, especially with respect to a case that the FCCPC investigated against the Meta platforms, and that has gone and had at least an initial judicial affirmation, one way or the other. I suppose other it will continue on appeal. But suffice to say that the technology companies and digital trade present a brand new challenge. First, data governance and control, which by far is the next biggest thing, and it's going to be for a very long time. And you have network effects, where one company is able to take advantage of its own infrastructure and the things it has done, or its first mover, or its own innovation, to the exclusion of others. And so those are the new challenges, and all of these are things that over a period of time have become part of the body of the history of the of competition regulation. And so the next thing is, all right, now we know the history, and I'm sure in this conversation about the history, you've seen some of what the purpose is. But it's good to also at least identify what the purpose is. And every legitimate government has an interest in protection uh, and a legitimate interest in shared prosperity. So one of the most important reasons for competition regulation is shared prosperity. And that is, everybody must have an opportunity to participate in the economy, whether for the purpose of compensation, or certainly for the purpose of fairness in what they buy or what they consume. And what I find interesting is that though we consider competition regulation a relatively new uh, enterprise in Nigeria, competition regulation, or at least aspiration, has been a fundamental principle, constitutional principle, from as far back as 1979. And so one of the theories we propounded while I was at the FCCPC, from a legal standpoint and from potential litigation defense standpoint, when questions of jurisdiction of the FCCPC arose, was to track competition regulation all the way back to the Constitution. And if you look in Chapter 4 of the Constitution, especially Section 16, it's very clear that it was the intention of the Constitution. It is the conscience of the nation that there's competition regulation of the marketplace. Because the Constitution provides that and Chapter 4, which has the directive principles of state policy, which require every arm of government, the judiciary, the legislature, and certainly the executive, to discharge their functions through certain lenses. And those lenses are the Chapter 4, it's the conscience of the country. And one of the provisions there is that to ensure that they discharge their functions in such a way that, one, welfare of citizens, which is consumer protection and competition legislation and regulation. Secondly, that that wealth and the means of production are not concentrated in the hands of a group or in the hands of a few. Put differently, that's exactly where the United States was when it legislated the Sherman Act in 1890. And so it's not some new import of what happens abroad. So it's not some new following the multinationals from their home countries to regulate them. It's a fundamental principle for shared prosperity, which really, at the end of the day, economic development of any nation, wealth of any nation, and uh, ultimately comes down to whether a country's people are prospering, in a manner of speaking. And so that's the real purpose. And that purpose is not something we have to infer or arrive at in Nigeria. It is fundamental. It is there. It was either a question of we did not make the connection or we ignored it. And what I found quite interesting is my research of the Constitution and my knowledge of competition work, and in preparing as part of developing the FCCPC, was recognizing that there was going to be significant litigation, significant contest and challenges to its jurisdiction. And unlike and my approach being a litigator myself before taking on the role was that one of the strongest ways of institutional development is litigation. The more case law determines the scope of the law and the playing field, the legal playing field, the more you're institutionalizing the work, the process, and certainly the existence of a regulator or any institution for that matter. And so Section 16, subsection 2 of the Constitution was a very interesting piece for me. And I started a new advocacy, and Moriah worked a lot on this also. And that was that the Constitution provides that the government shall establish a body that will regulate ownership of enterprise, business, and companies. And the default assumption that we had in the legal industry was that this was the Corporate Affairs Commission. And I propounded the argument that that's not the Corporate Affairs Commission. The Corporate Affairs Commission does not regulate ownership. And globally, any Corporate Affairs Commission or company registry is a register. It does not regulate ownership. Regulation of ownership in Section 16, following in the same section where the Constitution provides that the government shall exercise all its powers to ensure that there's shared prosperity and that the means of wealth and the wealth and the means of production is not concentrated in a few hands. A provision of law coming about that is really talking about fairness. It's talking about M&As. It's talking about making sure that businesses are not controlled by the same people. And so we argue that the FCCPC is that constitutional mandate. And the FCCPA, which is the act that establishes the FCCPC, is the legislature's performance of that constitutional mandate under Chapter 4. Establishment of the FCCPC, pursuant to the FCCPA, is the executive's execution or compliance with that constitutional imperative. And so we would argue to a court that it is now a judicial imperative or a judicial obligation to interpret the law in consonance with Section 4, Chapter 4 of the Constitution. And I've gone through this just so you understand that it's not that esoteric. It's fundamental and constitutional. And so if you can track it from that point, then you can at least see the legal argument for it and the constitutional imperative for competition regulation. So that's from a purpose standpoint. And what does it do? It's one of those pieces of legislation globally that serves a 360-degree purpose. Many times, legislation, or especially with respect to commerce or regulation, will focus on something. Maybe, for instance, the Consumer Protection Act primarily just focuses on consumers. An electricity regulatory framework will focus ultimately of the end side is consumers, but we'll focus more on supporting holding the electricity companies accountable, and whether it's telecoms or banking, that's what it is. But a competition legislation straddles both sides, especially when in the new theory of consumer welfare. It looks at the focus, everybody benefits. Companies are benefiting from it because small companies have a fair chance to play against the big ones. And big companies have a fair chance to play against each other in a market, in a competitive market. And when they fiercely compete, it promotes confidence in the economy, in the sense that everybody believes that they can get in there and find their own market and succeed. And when that is happening, the ultimate beneficiary is the consumer, because what does competition does? It promotes innovation, promotes quality, promotes fair prices, and promotes attention to consumers. Because consumers will not be loyal to a business that is not attentive to their needs or is not responsive to their sensitivities or their complaints. And so competition law and competition regulation done the right way actually benefits everybody. It's a 360-degree thing. So that's such an important um, benefit. And so it's one of the few splits between public law and private law. And I say that because you would imagine that competition regulation is entirely a public thing, which is a government institution that provides regulation. But one of the good things about competition regulation, and many jurisdictions have these provisions in their law, is, for instance, in the United States, you've got private antitrust action. Companies can proceed against other companies based on what injuries they believe they've suffered on account of the anti-competitive conduct of the defendant company. In Nigerian law, the FCCPA also encourages private antitrust action. And I remember while I was there was even an action at the tribunal once. Someone sought mandamus to compel the agency to do certain things against a company. In addition, even before the agency, before the FCCPC, other businesses, or even if the FCCPC would conduct an investigation and find that the certain market conduct was inappropriate and was against the interest of consumers. Companies that have suffered injury on account of that market behavior can present their injuries to the FCCPC, and the FCCPC can enter an order against the target of the investigation if it turns out that the investigation and the target of the investigation engaged in malfeasance. The FCCPC would enter an order against that in a way that remedies the injury that other company has suffered. And so that's an unusual piece of regulation where private entities benefit, not just the market benefit. And so competition law is that versatile. It's both public and private, both from a benefit standpoint, from an obligation standpoint, and certainly from a regulatory standpoint. And so I continue to say, and I think the evidence is pretty clear, that competition regulation is perhaps one of the strongest tools for regulating commerce, because you're regulating consumer behavior, you're regulating what consumers get, the prices they get it, and the quality and the innovation. And one of the biggest indicators of economic performance is consumer purchasing power. How much are consumers? I mean, you look at the United States, they measure the economy and what's happening in the stock market and consumer purchasing index. And that is correct. And purchasing is not just is a matter of price, satisfaction, quality, availability, choice. And so competition regulation is so important to economic performance and market expansion. And so that shows that it's not just a public issue, it's also a very private issue. And finally, it is by far the greatest intersection between social obligations of government and commerce, because it promotes inclusivity, fairness, and also a retributive system for dissatisfaction to be addressed by remedies. Uh, Now, this is the totality of what competition law is about. There are all kinds of key areas of it, merger review, because it's also, sorry, the last thing I was going to say is that it is also the one area of law that is as transactional as it is to as litigious as it is. Because you've got your merger review, which is M&A, pure, mostly transactional, and then the other pieces of it are investigations and determinations of malfeasance or conduct that violate the law, either in restraint of trade. And so a well-rounded competition lawyer is probably engaging in transactions, also engaging in litigation. And certainly one of the key areas where commercial lawyers are involved in regulatory work and government relations. So that is another important area. And finally, the social obligation and the social pact that citizens have with the government to protect them, to ensure that the market operates in a manner that serves their best interest and is as efficient enough to ensure that they get what they're completely entitled to. So, and then you have, so apart from the transactional aspect, you've got, which is uh, the M&A is more, we call it the ex ante, which is a more predictable. You're looking at a merger or a business combination and trying to determine how will this affect the market. Would it eliminate or substantially lessen competition, or will it distort the market? And so that's the transactional aspect, is like we always say, ex ante. And then the other part of it is post facto, which is now we've seen how something is behaving in the market. You want to correct it or you want to penalize it, or sometimes you want to both correct and penalize. Sometimes you're correcting without penalizing, sometimes you're penalizing and correcting. So those are the two key parts of it. And the last thing I was going to say is that it's one of the areas of law where it's extremely international. There are very few pieces of legislation that the world would accept to say a local piece of legislation that would have extraterritorial jurisdiction. And if you look in this in section 2 and section 3 of the FCCPA, you see the extraterritoriality is explicit. It's not by inference. It's explicit. It affects conduct that occurs outside Nigeria, but that has impact in the Nigerian market. And so you want to be an international lawyer, and you want to be a regulatory lawyer and a commercial lawyer at the same time, and potentially, possibly even a litigator. Competition law might be a good place to start. There's a whole lot more to unpack each of these things that we've discussed. For instance, you've got your abuse of dominance, your monopoly, you've got your restrictive agreements, you've got your price fixing, the bid rigging, and each of these is really big areas of law by competition regulation by themselves. And but I think that it would be too much. We certainly wouldn't even have the time to try and address each of these issues. But just for the purpose of at least understanding where it's coming from, because that will help understand each of these other areas. I thought that maybe this half an hour of discussing that would be enough. Thank you very much. I hope this has been useful.
Thank you so much, Mr. Rikera. This has been quite a teaser. And I'm sure when Mr. Rikera was talking, you heard him, ladies and gentlemen, say, job certain things, consumer welfare, and you're wondering how does consumer protection and competition law, yeah, even though the mandate is combined in one agency, sometimes, we struggle to make the connection. A few questions have dropped in the chat, and so I will go to them shortly. But I wanted to just sort of ask this question to maybe tease out more from Mr. Rikera before we go to those questions. And so I would like you, sir, in 5 to 7 minutes, to please sort of speak to how does competition law in Nigeria or in Africa broadly compare with more established regimes like the US and the EU? And I ask this question, given that the challenges are unique in different contexts, the African context, the EU context, the US context, the challenges are unique, the priorities are unique as well. And so, if I may remind you, you would recall the conversation we had when we were trying to set thresholds and the conversations we're having around protecting our small industries and also the fear around killer acquisitions. So that's one, unique challenge and it's not unique to us, but, protecting those small industries was a priority for us at the time when we're setting the policies. And so I just wanted to use that to tease out from you when you compare both, you know, Africa and then more established regimes, what would you say are the differences and the unique perspectives?
Very good question indeed. Very good question. And I'll split that question into two because I think both two topical issues there. One is the level of sophistication, the level of competition regulation, and whether we've come up to speed or not on the continent, and whether what we're doing is even adequate or not. And secondly is whether it's even appropriate, the appropriateness of it, and whether it's fit for purpose, considering the differences between what I would say Africa, yes, but what generally the world now considers either the global south or the global north. And I would start from the policy standpoint. Competition regulation is a piece of economic policy or constitutional imperatives. And so those local policies must play into the competition regulation. And taking Nigeria as an example, you want to strengthen your local market. And so competition must also look through those lenses of strengthening the local market, indigenous manufacturing, and all of that. And you find the balance, because if you're looking at consumer welfare, you always want to say, look, what should count at the end of the day is what the consumer is getting. It shouldn't matter. So it should be agnostic between what is locally produced and what is imported. But there are mechanisms to make sure that you're strengthening competition, and your competition regulation and your competition regulator are skilled enough, and you have a economic leadership in the country that is sufficiently skilled to understand the role of competition in the whole scheme of things, so that they are part of the discussion in creating economic policy, creating tax breaks, frontiers, subsidies, and all those things that either challenge or don't challenge competition, and all the things that the multinationals will tell you that you're doing it wrong and all of that. But you've got to be very clear about where the country is headed. And for instance, when we were at the FCCPC, it was very clear to us that these are the most important things to the country. The administration at the time had identified its priorities, and we regulated through those lenses. And so economic policy must be key. And countries must not be apologetic for prioritizing what they believe is in the interest of their homeland. I mean, and if you don't, then what's the whole purpose? The whole purpose of having your own regulatory framework is that. So, for instance, and I'll give you a quick example. Nigeria is a developing country from a global standpoint. And so we would adopt the underdog approach in our competition regulation when we're looking at ourselves against the West. But now, when you're looking at the continent and you're looking at the common market under the Continental Free Trade Agreement, Nigeria's status completely changes. Perhaps the largest economy, or the second largest economy, and certainly the largest market, and potentially the biggest actor on the continent, certainly the largest target from a market standpoint. So your considerations would begin to change. And countries must always look out for their own interests. I mean, the trade initiatives by the United States recently are the best example of what can happen from a policy standpoint. And I think that they present an incredible opportunity for us to also advance our own objectives. In the place of chaos is the best. I mean, actually look at the Nigerian informal economy. Chaos is when people thrive the most. I mean, and all you really just think about a flood in Lagos. The Okada riders, everybody starts to find their way to chaos. Broken down vehicle on the expressway, mechanics, everybody. So we have a global economic chaos. So it's the opportunity for Africa, including Nigeria, to make certain rules of its own that it's going to live by and will get away with. And so that's what I think from a policy standpoint. Now, to the question of whether we're still premature from a skills and regulatory standpoint, yeah, of course, the body of work, the sophistication of the economies are very different. But what I found in the last half a decade on the continent, especially after Nigeria came on stream in 2019, is that things have moved very quickly. And I'd say that the FCCPC is, from a sophistication standpoint, a contemporary globally. It might not be handling cases nearly as big or as intense, matters nearly as big, but from a core of understanding, from a courage to engage and then to take on the very complex discussions or controversial issues globally. The FCCPC has distinguished itself, including rising very quickly to one of the agencies globally that have held big tech very accountable, and their decisions have been affirmed and have imposed significant penalties on multinationals and have confronted things like the digital. In fact, Nigeria is considered one of the countries that has moved quite briskly or rapidly in digital platforms regulation, including loan applications and other platforms. So I would say that the continent is moving very quickly. I would say prior to when Nigeria did some of these things, the continent was still relatively behind. But the courage Nigeria has demonstrated has inspired that courage in other places also. And one other thing is that the continent has bonded together. There's a community, the regulatory community has bonded together. And I remember when I was there, we took leadership in trying to strengthen those relationships. And so that allows the continent to speak with one voice. And so I'd say that watch out for Africa as far as competition regulation is concerned.
Thank you so much. Just before we go on, I would like to let everybody know that a link has been dropped in the chat. So please click on the link to claim your CPD points. So now I'll move to the questions in the Q&A box. And I'll just try to take them three at a time. Mr. Iker, I believe you can see the questions as well, but for the
I'm going to
sake
go
of
to
the
them
audience,
right
I
now.
would.
Sorry.
Okay. So it says in Nigeria, the first question from Mubarak, in Nigerian legal jurisprudence, is it right to say that no specific law regulates monopoly? And where is the law? There is no penalty for infringement of such law. That's one question. The other question relates to understanding Nigerian competition law aims to protect consumers as well. What would you say restaurant companies on the island would charge both VAT and consumption tax and service charge in addition to food price in the invoice? Is this right or exploitative? What can be done?
All
And then
right.
there's a third question. I want you to take those three questions together.
Okay.
What guides the commission in the choice of whether to penalize or simply demand correction? So please, sir, over to you.
Excellent. So the Nigerian jurisprudence absolutely has clear provisions of law to regulate monopolies. The FCCPA, trying to remember what path that is. That is comes right after the merger review rules, starting from I think I want to know before that. I think maybe
I think
starting
it's
from
from
about
around 70,
70,
71.
from section 70 to about section 80 something. And it identifies how to regulate monopolies, including monopoly investigations and what the remedies are. It also identifies the role of the commission and then the role of the tribunal in providing remedies to monopolies, including when the commission can recommend the breaking up of a company into multiple units and where the tribunal can make that order. So yes, there is a specific provision of law that makes that provision. And the second question is understanding that Nigerian competition law aims to protect the consumers as well. What would you say restaurant companies on the island who charge both VAT, consumption tax, and service charge? And so taxes are a matter of law. There's no discretion. Companies should not be able to impose a tax on consumers that there isn't a statutory basis or cover for. And so this is a question for our tax system. And the good thing is that there's a new tax legislation that seeks to consolidate taxes. But where any company imposes a tax on consumers that other companies do not impose, first, that company is violating the law from a tax standpoint. But there's a competition angle to that because the company is doing something others cannot do and which it shouldn't get away with. But primarily, it's a secondary consumer protection or competition regulatory issue. It's first a primary tax violation or simple criminal conduct by the company. Then the third question is, what guides the commission in the choice of whether to penalize or simply demand correction? A bunch of different things. At least when I was there, in the early stages, we chose not to penalize while we were trying to get everybody accustomed or accultured to a new competition regulatory environment. And that was also in part because regulations can be very steep. But what determines whether you issue corrective measures or penalties, not just the commission, but globally, is the nature of the conduct and the behavior of the target. So, for instance, if something is not a first-time conduct, if something is very egregious, so there are some things like price fixing, whichever way you're going to penalize, because that is so abhorrent Now, there are other things where companies are not aware that they're doing the wrong thing. But many times, when you conduct an investigation, if it's a very detailed investigation, you're going to see when to penalize or not penalize. You're going to see when a company has engaged in conduct that it knew was illegal, and you're going to see sometimes the devices that the company went through to conceal its conduct, or to mislead, or to obstruct the investigation. So there are a whole potpourri of many different things that determine whether to penalize which one. The conduct. There's some things that you decide that, you know what, for our market, we cannot even tolerate this. It's a zero tolerance. For those types of things, you must not just as a retribution for who has done wrong, but as a deterrent to everybody else not to do the same thing. And then, secondly, I also firmly believe that consequences is the greatest modifier of behavior. For people who have made revenue inappropriately, uh, just correcting that conduct is not sufficient bar for them not to do it or for others not to do it. You must disgorge what you've made from your inappropriate conduct, because that's when it makes it uh, um, uh, senseless to do it again. So, but again, there are no hard and fast rules, but there are many tools and guides in how those decisions should be made. Thank you.
Thank you so much, Mr. Rika. So at this point, I would like to, I've just been informed that the immediate past chairman is with us, and I would like to acknowledge the presence of Dr. Adeoye Adefulu in this webinar. Sir, please, if you are here, we would like you to unmute and make a few remarks if you so wish. Thank you so much. Dr. Adefulu, please.
I do not so wish. Thank you.
I would have loved you to wish. Okay, thank you so much for joining us. We're really honored to have you here. Okay, so I will take the next three questions. First one here says, in the area of merger and acquisition, it has been said that the rules are heavily tilted against collaboration and growth. What is your take about this? There's another question that this question is asking for the judicial test of the jurisdiction of FCCPC that you earlier mentioned. And somebody also wants guidance on how to develop competence in this area of law as a new wig. So, sir, let's take those three questions because I see the next one has like four questions in one. So,
Oh,
over
I
to you,
mean,
sir.
so for the attendee who says it's been said that the rules are heavily tilted against collaboration and growth. Actually, I think to the contrary, and the volume and the activity of M&A in Nigeria demonstrates the absolute contrary. We've seen, I mean, Nigeria has by far the most robust M&A jurisdiction on the continent right now. I mean, there's company, you'll be surprised how many transactions are going on. And what the rules, in fact, in setting the thresholds, as Mariah said earlier on, what we sought to do was to find a balance instead of just ring fencing small companies and saying that bigger companies cannot combine or you cannot eat up a small company just so that they can grow. What we did was to find a basis or a ground where companies could grow, recognizing that business combination were a way for growth also. Because there are two things. I mean, Nigeria is a country where you have, what, at the last count, I can't remember if it was 36 million or 34 million SMEs. And so one of the ways of strengthening these businesses is for them to be able to combine. And sometimes the combination is not SMEs combining. Sometimes it's an SME combining with a big one, because that brings capital, it brings governance, it brings skills, expertise. And so I believe that, and we've seen a lot of that. As a matter of fact, we have very, very, very low, if any, record of M&As that have failed in Nigeria. And we also have quite a low record of M&As that were blocked or prohibited. On the contrary, what we've seen is M&As where remedies have been imposed. And why would you impose a remedy? Because you still want the transaction to occur as best as you can, but you impose a remedy so that it doesn't distort the market. So for the next question is a judicial test. There are quite a number of cases quite a number of cases. I doubt that any has made it to the Court of Appeal. There are at least 3 or 4 cases that I recollect from the tribunal, in which one of the cases I was lead counsel after I left the commission, which is WhatsApp and Facebook against the FCCPC, where I was lead counsel. And then there are the number of the cases where I was lead counsel while I was in the commission, criminal cases where the jurisdiction of the agency was challenged in certain industries like medicine, pharmaceutical, where the courts dismissed the challenges, the cases where we prosecuted and where I led the prosecution myself and ended up in plea bargains, which is the strength. So there are quite a number of cases, and both in Abuja, Lagos, and elsewhere. There's a recent case by a shareholder of MTN where they tried to say that the FCCPC had absolutely no powers to demand information about what was happening on the board of a publicly listed company, and that regulating a publicly listed company in the telecom sector was both the NCC and the Securities and Exchange Commission, where not only did the court dismiss the preliminary objections, but also went on to clearly state what the jurisdiction of the FCC. So there are quite a number of cases, and if you just, I suppose, if you use the right keyword searches, even on Law Pavilion, you might be able to find some of them. And then the next question is, as a new week, well, the first thing I'd say to a new week is that if you're writing this, you're already on track. And so you're paying attention and demonstrating your interest in the area by attending discussions that focus on that. And I would say that start by reading. Start by reading, research this case law that we just discussed, and interact with the agency as much as you can. Do your desk research. The agency's website is quite a useful tool and a resource. Because I remember when we were developing the website, we didn't want a website that is just for presence. We wanted it to be a resource where people could go and read up materials. And so release after release, just reading the public releases, you'd learn a lot from that. Reading the cases, the regulations, the rules and the guidance documents and the guidance notes and the guidelines that have been provided would help. And also seek mentoring from experts in the field. So those would be my initial advice to a new week, because and it's still a young area of regulation in Nigeria. So if you focus a lot on that, it might be a new lawyer week, but you can quickly become an old week, even older than older weeks in the competition space.
So very much. We still have 13 questions open. I see that some of them are comments about CPD points, so I will close those ones. But I would like to crave the indulgence of everyone to please give us maybe another 10 minutes. Mr. Erikara, please, we're craving your indulgence if your schedule permits, to stay with us for an extra 10 minutes so that we can fully address this question. And if there is appetite, we're open to going again with our cup and begging for some more of Mr. Erikara's time to come back for a second session. So, but for now, please, let's address the questions that are on ground. And I understand that there may also be some questions on YouTube. So please, if everyone is open to that. So the next set of questions, there are 5 questions from Fumilola Adeogun. Wow. And Mr. Erika, you can see them. I don't want to
Yes, I
spend time
can.
reading them out so
Okay,
that
so should I
saves us
proceed?
time. Yes, please, sir.
So what are the most significant challenges in enforcing competition law in Nigeria, and how can they be addressed? Number one, the most significant challenge, I would say, is subject matter expertise. So there's an capacity, and this is both across the board, certainly at the bar, at the bench, even in the regulatory authority. We were burning the candle from both ends to do the things we did, because we were gaining expertise as we were going, being that it was a new area. And I think the most expertise is still in the agency now, because it's still a young area. On a broader note, the greatest pushback that I experienced regulating competition was actually from consumers, from the people. Even for consumer protection, I was far more abused by the people who set out to protect than the businesses themselves. And then we can hide from the fact that we struggle in Nigeria with regulatory capture. And so others in government oppose you, sector regulators want to protect their turf. And so those were real challenges when you have to confront um, fellow contemporaries like you in getting your work done. And when businesses who prefer to deal with the sector regulator than an independent regulator now use the sector regulator to promote conflict between the FCCPC and the sector regulator. And then finally is on a broader level, a better understanding of the role of competition and how it can, the role it should play in the economy at the very highest level of government. I think that that would help all the way from the presidency down to the Ministry of Industry, Trade and Investment, and further down, cascading it all the way down across the board, and especially at the presidency level. If they understand the importance of competition and how it unlocks the market and protects citizens, I think it can cascade across the board from there. Of course, legislative training for the legislators and certainly judicial training for judges, so that when these cases come before them, they understand exactly what is at stake. Because the one area of law that should not end up in a courtroom and become the black and white letter of the law is competition. Because it's really about people and their lives. You must be able to understand the fundamental principles and exactly what the case is about. Once judges can understand that, then they can at least cut through the chase in what the case is at. And how can competition law and policy be used to promote economic development and growth in Nigeria? I think I've just said that. First,
Yeah.
I think one of the most important things you can use for promoting economic growth and policy is competition law. As a matter of fact, it's actually one of the biggest tools of diplomacy. It's the biggest tool for balancing trade. And so it is by far, with a strategic understanding of it, I mean, I think it's the number one go-to for economic development and diplomacy. What are the implications of the Federal Competition and Consumer Protection Act for businesses operating in Nigeria, and how can they ensure compliance? The implications are that comply. If you don't comply, you could be exposed to significant penalty, and that's the primary implication. And what are the implications, and how can they ensure compliance? Number one, pay attention. Pay attention and be intentional. Develop a compliance system within, and make sure your compliance policy and system is not just to fulfill all righteousness. Make sure you're training people and making sure everybody who's involved, and it's not just for your legal department, it's not just for your executives. I mean, I remember one particular investigation where at the very senior level in the company, they understood competition policy, but at the very low level, the sales people were speaking with other competitors and asking them, what are you doing? Can we do this together? So you must cascade policy all the way down so that people who operate on your behalf do not violate the law. Then how does competition law intersect with other regulatory frameworks in Nigeria, such as sectors? I think we just spoke about that. They do intersect, but the FCCPA makes it abundantly clear that the paramount and preeminent piece of legislation with respect to consumer protection and competition regulation is the FCCPA. And case law has determined the interaction between the FCCPC and the other regulators, and when the FCCPA will dominate and when it will not. And I think that, yes, the Patrick Chukwuma and Peace Mass Transit case out of, I think that would have been Anambra State, is one of the cases that has determined that. The case I just mentioned with Emeka Mwobia or something against FCCPC and MTN is another one. Case of, I think it would have been Fact Supermarket, Ebano, and one other supermarket that I prosecuted, and the objections they made in court. Those are case law that have defined that as much as possible. I think there's also a case by multi-choice that clarified the role of the regulator in price regulation and the jurisdiction of the commission. And then there was also another one by Eco Disco. So there are a number of cases that have determined the jurisdiction of the commission. And then I think the last question with that, I think that was the last question with that. And then should I proceed with all the other questions?
Yes, please, as much as you can.
There's a question by Frank Lerum. Hi, bro, how are you? Beautiful introduction and overview. Does our legal tradition impact the ability to deal with innovation and competition, especially in the technology space? Well, our legal tradition needs to come up to speed. Judicial process needs to by itself understand. I mean, the evidentiary process for the kinds of evidence that need to be established in litigation before the courts. It's quite challenging, as it were, right now. And some of the greatest defenses that were propounded by by a large tech company in the investigation that I led were purely based on our legal system. And when they propounded all those things like the fair hearing, things like the snip test, and all kinds of things for the tribunal, but luckily the tribunal did an incredible job. So there is a lot more we need to do, a lot more training. But I think more fundamentally is an opening of the mind and orientation. The training part can come once the minds are open. So advocacy must continue. But I agree that our legal tradition does impact ability to deal with innovation and competition. I mean, in innovation, for instance, we're still dealing with issues in copyright and intellectual property, which are all areas that one way or the other, the ecosystem for competition regulation is either efficient or ineffective based on those other pieces of the ecosystem. Next question by Mr. Bulai. What is the role of competition law in ensuring fair price control? I think we've just said that. Competition by itself is the fairest price control mechanism. A fair and a very competitive market is the best price control mechanism. The only thing is that it's a free market that is not distorted. If the market is free and not distorted, whatever the price of anything in that market would be the fairest price. But when you have only a few players, when there's a dominant player, where there's a monopoly, or when there's price fixing, once the market is distorted, then the price isn't fair. And so the role of competition is to continue to ensure that the market is not distorted, where there are only a few players scrutinizing, monitoring, and checking to make sure that they're not engaging in conduct that restricts supply, that fixes prices, or in any way that signals to each other what they're doing. They're not allocating the segments of the market to themselves. Where the market is not concentrated and making sure that there are no barriers to entry, others can just enter the market in and out. Those who want to exit can exit. And so once you have a very strong competition regulation, the greatest likelihood is that the prices will be fair. And if you look at one of the reasons why prices are skyrocketing is, of course, there are other issues. There's inflation, which is global. There are foreign exchange issues. But there is a piece that competition can address. Can address everything, but there's a piece that it can address. And then Suleiman Sheu, when could it be said that monopoly is contrary to the freedom of association in perspective of business? Freedom of association is completely different from monopoly. There's always trade associations and trade unions are actually encouraged by the FCCPA for standards, or even for engaging for self-regulation and policing themselves. But monopoly is about holding all the means. Abuse of dominance is about having a dominant position and abusing it. Dominance itself is not a problem. The abuse of it is the problem. And so the association is a completely different thing from monopoly. Mr. Odo, Oluwasegun Odo, on the issue of consumer protection, there have been huge differences in the qualities of products and services when juxtaposing same between international best standards and what is provided or produced in consumption for Nigeria. Case study, multi-choice. What is the FCCPC doing? The FCCPC, well, that's a question for the FCCPC. But I would say that the FCCPC would do what it can. But standards are not the core of the work of the FCCPC. For instance, in food and drugs, you've got a NAFDAC. In other areas, in the DSTV and other, you've got the NBC. In all kinds of other things, you've got the SOA. The FCCPC is not a standard-setting organization, but it must enforce the standards that have been set by other organizations. I'll give you a quick example. For instance, in the carbonated soft drink market, there's what you call the Codex, which is a global document for the standards. And so you have standards for benzoic acid, coloring, and all kinds of things. And so some countries would, the standards range somewhere from about, for benzoic acid, I think it ranges from somewhere between 50 and 250. So each country, by their NAFDAC or their SON, will adopt a standard. Now, Nigeria's standard, the last I recollect, was probably 150. Ghana's standard is 100. And so there was a case at one time where NBC had been sued because somebody exported Fanta and Coke from Nigeria to the UK and it couldn't make it in. They said it was substandard. And people thought that, NBC is bottling substandard products for people in Nigeria. No, those drinks were bottled in accordance to Nigerian standards. But UK has its more stringent standard for less benzoic acid and coloring, because coloring has sugar. Okay, and so the standard setting authorities must also be unscrupulous in setting the standards for the market so that a consumer protection regulator, because for instance, there's nothing the FCCPC can do to any business, no matter how poorly its product looks or tastes, if that product is manufactured to the standards by the applicable standard setter. Does the FCCPA have provisions for foreign-owned supermarkets whose prices are outrageous compared to market prices in Nigeria? At the end of the day, what it is that the FCCPC would look at prices from two standpoints. One is a fairness standpoint, which is competition regulation, so they don't impose prices. The only thing that time the FCCPC will intervene in prices from a competition standpoint is price regulation when there is a distorted market, and for a limited period of time, the FCCPC can investigate, make a recommendation to the president, and the president would impose a price regulatory period for a transitionary period. Now, on the consumer protection side, there's price gouging, which prohibits manifestly unreasonable, unjust, or unfair price or contract terms. Now, it's not just language. There's a matrix to calculate whether price is manifestly unjust or unreasonable. And so, yeah, you can complain about, and it doesn't matter whether something is imported or locally produced. A manifestly unjust price is manifestly unjust if it complies with the calculation matrix. Do we get
Thank you
access?
so much, Mr. Erica. No, I think the SBL secretariat to respond to the
Okay.
question. So there's been a few questions for the secretariat, please. There's been a few questions around the link or comments around the attendance link not opening for the CPD points. And then also people are requesting access to the recording for the session to be able to rewatch it. Thank you so much. I don't know if anybody from the secretariat wants to respond to those two questions now. Mr. Erica. Thank you very much for your time. Is somebody from the SBL Secretariat going to respond, please? Or should we proceed?
Yes,
Okay,
I
please.
will. Okay, so the link has been shared multiple times, I guess because so many people are trying to access this at the same time, so it probably clogging. So, but please just give it a few times, maybe 5-10 minutes interval, you try again. But we'll leave the link open up until say 5 p.m. today so that people can access it. And of course, the recording is already on YouTube, so you can go on YouTube and view it live. Thank you.
Okay, thank you so much. Chairman, sir, any last closing words from you? I think Mr. Erica has given us a
yes,
earful,
certainly.
so please, over to you.
I certainly have a few things to say.
Yes.
I think this is just the start. My appetite just got whetted, and I'm not. Sorry, I have my video on. Yeah, so my appetite just got whetted, and I think we must prevail on Mr. Rukera to come back. Eh? So as part of our series, we always have time for you, and I hope everyone has enjoyed this as much as I have. It's really, really important for business lawyers to have an understanding of competition law, whether you like it or not. It's going to loom larger and larger. For young lawyers, people like us, we've gotten into this gig at a rather old age, literally on our way out. So for younger people, I think you can look forward to a career specializing and practicing in this area. And the thing about competition law is that it extends beyond our borders. So it's not only going to be in Nigeria, you can do it at a regional level, at a continental level. Okay. So I hope you've enjoyed it all. And again, thank you to our mother organization, to the SBL. Thank you, former chairman. We have to talk later. It's been a while. But otherwise, I would say thank you to everyone, and I hope you will attend the rest of our series. Over to you, moderator. Shut down.
Mr. Erica, we must thank you so much for making out the time. I know how tight this particular session was for you to make, but I also know your passion for knowledge sharing, for educating, and so I knew that we would get away with it. So thank you for allowing us get away with it. Thank you everyone for your attendance. Thank you so much, Chair, for always being there supporting us. And thank you particularly to SBL Secretariat. Thank you for your ever-present support. Thank you all. Have a good day. I hope it's okay to close now. Anybody else? SBL Secretariat, any other remarks?
All good. We're good.
Well,
Okay,
nothing
great.
from here. Thank you, everyone. Thank you all.
Thank you so
Thank you,
much, everybody.
Dr. Irukera,
You got a
Thank you very
doctorate degree
much.
now.
our chair. Thank you.
I suppose I just defended my thesis right here today then.
Yes, you
Mr.
did.
Hayoko, thank you so much. Thank you,
Thank you.
everyone. Participant, thank you. God bless you all.
Take care.
All right. Thank you, everyone. Bye.